A ruling today from the Maine Supreme Court casts more shadows on the future of the controversial energy corridor project from Central Maine Power's parent company.
So a bit of background. Years ago, CMP proposed connecting to hydropower in Quebec to support the New England energy grid. Since then, the project has split off from CMP to be run by the utility's parent company, Avangrid. The project got a lot of permits and approvals, but last year voters rejected it in a citizens' initiative referendum.
Lawyers for the corridor appealed that decision, and the state Supreme Court heard arguments on it in May. Now, Maine's top judges say Avangrid has a point, at least in part. Corridor lawyers said the work that construction crews have done on the project so far earns them what are called vested rights, and taking those away with a new law after the fact is unconstitutional. The judges agreed and kicked it back to a lower court.
Another part of the appeal, a debate over land use, has yet to be decided. News Center Maine's Don Carrigan has been covering the case and joins us now with more on what today's ruling means. Hi, Don.
Hi, Samantha and Chris. A couple quick points. Obviously, all the sides in it are making their statements, but the law is still in effect as it was passed by voters. The court did not overturn it. What it did rule was on that one piece about the vested rights that you mentioned. Basically, there's a doctrine in Maine law that says if you've done all this work, you get vested rights, and those can't be taken away from you just because the law gets changed. A key part of that referendum, you'll recall from last year, is that it applies some portions of the new law created by voters retroactively, back to 2020, before the actual construction began. And that's the question that the court says, if the company has vested rights from doing all of this construction, like $480 million worth, then taking those away retroactively would deprive them of a constitutional protection. So the business court, Business and Consumer Court, is now going to hold a trial or a hearing to determine if indeed the project has vested rights because of doing all that work. Remember, the 53-mile new section of the corridor is almost all cut and cleared, so that's what it says the vested rights are involved with.
So, Don, now that folks are kind of caught up to speed here, what happens next?
Well, two things. One, there will be this new hearing or trial on the vested rights issue. No word when that might happen. But there's another big shoe that we're waiting to drop, which is the other case the Supreme Court is in the process of deciding. And that's about the transmission line, the NECEC, crossing a little less than a mile of state-owned public land. A lower court ruled that the project did not have the needed approval of the legislature in order to get that permit. The State Bureau of Public Lands granted the permit to the NECEC not once but twice, one in 2014, one in 2020 again, and saying it didn't need legislative approval. The court, the Superior Court ruled otherwise. That's been appealed to the Maine Supreme Court, and I'm guessing that now that we've had this decision, we might hear from the Supreme Court possibly this Thursday about the public lands case. So if they uphold that lower court ruling about public lands, that means CMP will have to change a portion of its route in order to build the project. So in essence, this is significant, but there's clearly more court time, a lot more detail to go in this before we decide one way or the other whether it will be built or not.
And so, Don, just to clarify, it sounds like it's that land use issue, that second court case, that really could be the potentially determining factor on if this project has to be put on a serious pause or possibly even stopped. Is that right?
Well, it's paused because it's currently paused both because of that and the referendum. So that the public lands issue is a critical one. It applies to just that piece of the 53-mile new section of corridor, roughly a mile of going through over a section of public land north of the Forks, northwest of the Forks. And if the court upholds that and says no, says the project needed legislative approval, which it didn't get, then it either has to go to the legislature to get that, which seems highly unlikely, or it needs to find an alternative way around that land. And that would seem to be a process that would take a very long time, require more hearings, all of that.
All right, Don Carrigan, live for us in the Mid-Coast this evening. Thanks so much.